Um, Good afternoon to our participants. Thank you for joining us today for our webinar on Justice in the Eye of the Child. It has been a series of webinars where we get to discuss on justice issues as they pertain children. In our laws, a child is defined as anyone who is under 18 years, and meaning that will be the topic of our discussion today. There are so many things that come into play when you talk about a child in light of justice. A lot of times when you hear about justice, you just think about the court, but beyond court, there's so much that goes into play. We look at the psychosocial welfare of the child. This is what most of us refers to counseling, like psychosocial welfare of this child. We look at the legal needs of this child. That's why they find themselves from the police station to the court. We also look at the the medical needs of this child. So when you're looking at a child's needs, I look at them three-pronged. There's the psychosocial well-being, there's the legal well-being of this child, and also what we can never underplay, which is the psychosocial support that this child requires, and which will form the backbone of our discussions today. So with us, we have three panelists who will be sharing on the three things that I just mentioned, majoring on the psychosocial support, the mental well-being of a child as they go through the justice system. We have with us Ms. Margaret Terry, whose introduction I'll give prior to her presentation. We're also joined in by Honorable Gitonga and also a children officer, Mr. Ezekiel Kimani. So without much further say, allow me to welcome Madam Helen Namisi from the LSK Secretariat to give the opening remarks. Karibu sana, Ms. Helen.
Thank you, Joy. Good afternoon, everybody. My name is Helen Namisi, and I am the Vice Chair of the LSK Nairobi branch. On behalf of the branch and on behalf of our chair, I would like to welcome you to this webinar this afternoon. Apologies from our chair who is otherwise engaged. The Nairobi branch is mandated to address practice and welfare issues for advocates working in Nairobi and Kiambu counties. And in line with that, we also do undertake public awareness activities, just like this webinar we are having this afternoon. And so the Nairobi branch, and in particular the Legal Aid and PIL Committee, has a keen focus on educating the public through awareness webinars such as this one. Today, we shall be discussing how children who have faced trauma are handled within the justice system. And we are very delighted and privileged to have three speakers who are quite knowledgeable on this subject. Many children have undergone various forms of trauma, especially during this COVID-19 pandemic. And some of us may be aware of the statistics right now regarding the trauma and abuse that children have undergone. And so this afternoon, we are delighted to invite you to this webinar and hope that all participants will leave this webinar this afternoon with insights of how to approach the court, the roles of the various actors within the system, and even our role ourselves as individuals and as advocates towards the children of our society. So I would like to take this opportunity on behalf of the branch and our chair to welcome you to this webinar and to thank most specifically our speakers who will be addressing us this afternoon. Karibuni, and do have a pleasant time. Thank you.
Thank you so much for the beautiful opening remarks from Madame Helen, who serves as the Vice Chair of the LSK Nairobi branch. And quickly, we'll move on to our first presenter, who is Ms. Margaret Terry. I'll take you through a brief bio of who Ms. Margaret Terry is, but I'm sure this is just a small bit of species that we tried to compress. So Margaret is a clinical psychologist and practicing child therapist. She holds a bachelor's degree in counseling psychology, a master's degree in child development, family studies major, and is currently a doctoral candidate in Margaret is a clinical psychologist and a practicing child therapist. She holds a bachelor's degree in counseling psychology, a master's degree in child development, family studies major, and is currently a doctoral candidate in doctorate in clinical psychology at the USAE. She is the co-founder and director of Sterling Performance Africa Limited, which is a leading consultancy firm based in Lavington, Nairobi County. She's also a co-founder and lead clinical psychologist and child therapist at Diamond Therapy Center. Margaret is a student counselor at the Technical University of Kenya. Margaret is a passionate advocate of mental health and a trainer in childhood trauma. She spends most of her time working with children with trauma experiences and specifically those transitioning through the justice system. She's a member and a past vice chairperson of the Aga Khan University Ethics Review Board and a member of the United States International University, that's USAU Africa Ethics Review Board. She is a mother of 2 young adults, a mother-in-law, and a grandmother to a 16-month-old grandson. What a beautiful way to sum it up. So with that brief introduction, karibu sana, Ms. Margaret, to share with us what you have prepared. I want to remind our participants to make use of the chat box. If you have any questions directed to our panelists in the course of their discussions, kindly drop them on the chat box. We'll be able to respond to them. We're also streaming this live on our Facebook page, the LSK page. So if you're not able to join in the Zoom meeting, you could also catch up on the Facebook page. So with that, allow me to again welcome Ms. Margaret. Karibu sana.
Thank you so much, Joy. It's a pleasure to join in this afternoon and to make this presentation. So I'm actually honored. It's such an honor to be part of this presentation. So I'll share my screen if you allow, and we're looking at justice in the eyes of the child, and my presentation will be on the different forms of trauma that children, especially in the justice system, are presented with. And then we'll also get to look at why is it important for us to understand these children as they transition the justice system, and how is that understanding of the trauma very important for us, especially as players and key players in the justice system. So we'll start by...
Sorry, Ms. Njehia. If you could be slightly louder, a few members are not hearing you.
Oh, okay. Let me... Sorry about that. I don't know whether that's better now. Is that a bit better?
Yes.
Okay, all right, thank you. So saying we'll start by, basically my presentation will look at the different forms of trauma that children in the justice system go through, and why it's important for us as the key players in the justice system to have this understanding. So as we interact with children, then we need to appreciate that it's not just your ordinary child, but it's someone who has some background that we need to take into consideration. So as we move on, I want to start by just looking at what is it that children need, and children across the board, whether it is this child who is entering the justice system or the child who is not entering the justice system. And one of the basic needs for the children, it's not even really the things that we think that children need. Children just need this stable, sensitive, loving, a stimulating relationship and environment. If they are going to thrive, if they're going to achieve their full potential, if children will not get into the justice system, children are looking for this, not the big things that we think about, but most importantly, a stable and a loving environment. As long as they have that, then they are well grounded. then it's very important for us to appreciate that children are very, very vulnerable to witnessing and experiencing violence, abuse, and whatever neglectful experiences or circumstances they go through. And any child in the justice system, whether in contact with the law or in conflict with the law, and specifically those ones in the conflict with the law, one of the things that is a sure bet about them is that they have an experience of violence they have witnessed, or abuse, or whatever form of neglect that they have experienced. But however, I know when we look at them, our first impression is this is just a child who is in conflict with the law. And I don't know if we ever stop for a minute to even do in-depth background check and ask ourselves, where is this child coming from? And childhood trauma is, or what we refer to as adverse childhood experiences. And they are adverse because, number one, the impact is so severe. And number two, they happen to children. And in Kenya, we talk about children as below the age of 18. And because they are children, then they are vulnerable because they are dependent on other people. And they are also adverse, especially if they happen to a child who is below the age of 18. So there are 10 categories divided into 3 broad categories. Now, these adverse childhood experiences or events, when we talk about abuse, then we have 3 forms of trauma that children go through under abuse. We have physical, we have emotional, and then we have sexual. And the thing about any of the 3 categories, a child who is physically abused, it goes without saying that they're emotionally abused. A child who is sexually abused, it's also obvious that they have some form of physical abuse, whether it's pushing, the pinning down, or whatever it is, and is also accompanied by emotional abuse, which is, shouting, intimidation, demeaning this child. There's no way a child will be sexually abused but doesn't experience the other 2 forms of abuse. Then we have neglect. And neglect involves physical neglect, where the child is not taken care of by the primary caregiver of the child. And physical neglect also is accompanied by emotional neglect. And of all the 3 categories, broad categories of the child abuse or child trauma, neglect is the one that has more impact. It leaves more impact, it's more painful, and it's what now will lead most of the children to enter the criminal justice system, especially those in conflict with the law. Because then this child, their basic needs are not met, and that's where the physical neglect comes in. They're not in school, they don't have medical care, they probably don't have anyone who is taking care of them. They are all by themselves. And then we have the household dysfunction, which carries more, actually 5 of them. And the other children in the justice system, like those who not directly because they are either victims, or maybe because not directly because they are the ones who are coming in with an offense, those children whose parents have separated, or with an experience of divorce and separation, then you can also, it goes without saying, there's a likelihood they will also be experiencing some form of neglect, whether it's physical or emotional. And like we know in some divorce and separation cases, then it also comes with a bit of physical violence as well. As parents are busy fighting and tearing each other apart and down, then we know that children are actually neglected. Children who witnesses a lot of violence at home, not necessarily restricted to the mother, it also includes the father, or it also includes the children who are witnessing other children or other family members being physically or violently treated, are also classified as a child with a traumatic experience. Children growing up in a household where either one of the parents or a close family member has a mental illness, because then again, it's also it's also highly associated that where there's mental illness in a family, especially if it's a parent or a significant caregiver of the child, then they also have an experience of neglect. Just as where there is violence at home, there's also an experience of neglect. Children, of course, growing up in a family where there is an incarcerated relative, and especially where the incarcerated relative is a mother, then those children will lack, or they also have an experience of the neglect, either because the family is not in a position to take care of their basic needs or meet their basic needs. And also children who are growing up in an environment or a family where there is a history, or they're also a parent or a family member of the primary caregiver is using drug and substance use or alcohol, then is also a child. Sorry, Joy?
But we are having feedback that you're not audible.
Sorry?
So, I'm saying sorry to interrupt your presentation, but we are having feedback that you're not audible. Maybe you could try adjusting your microphone.
Okay, let's try. Can you hear me better now without okay, let me show you. Let me see what I can also do. Can I log in also with my phone if my laptop voice is not strong enough?
As she continues sorting the technological hitch, kindly share any questions that you have on our chat box.
Joy, for some reason, we also can't hear you.
Until now?
Okay, sorry about that. Is that better? Now?
Yes, it is, but you'll need to mute your laptop.
Yes, I have muted. Okay, just a second. I know what I need to do. Now that it doesn't have an echo, right?
Yes.
Okay, sorry about that. So do I need to take back this slide again?
Maybe you can go 2 slides back.
Okay, sorry. Sorry about that. So we're saying it's important for us to first and foremost understand children and what happens with children, and what do children really need, and what are some of the issues that if those variables are not there, or if those conditions are not there, that push children into getting into the justice system. And we are saying that the only thing that children need is this very stable environment. And by stable environment, we mean the parents are there, there's consistency, there's care, there's a deep sense of understanding and appreciating of the child. The environment is sensitive to this child. They are loved for who they are, and not necessarily an environment where there is money or there are expensive things, or that is living in a high-end place. The children love that stability and that consistency. And as long as they experience that, then they are okay, they are comfortable, and they feel like their needs are being responded to. Then the other thing about children is that when children witness violence, or they themselves experience violence, it's so impactful that it sits with these children for the rest of their lives. And the adults that we are today, and the adults that we also find transitioning in the justice system, they are as a result of their early childhood, and especially
if the witnessing experience and the experience of violence happened to them in their early childhood below the age of 10, then that in one way or another informs what is going to happen to this child. So in our interaction with children, whether you are defense counsel, whether you're the prosecutor, whether you're the magistrate, it's very important to understand who is this child? Where are they coming from? What is the kind of a background they are coming from? Do they have any trauma experiences or any experiences that make this child more vulnerable than any other child? And that's why assessment of vulnerability for a child in the justice system is paramount. We don't have a choice, but we just have to make that assessment to check their vulnerability. So we're saying there are about 10 forms of trauma experiences that children go through. These trauma experiences are divided into 3 broad categories. When we talk about abuse, we are talking about an experience of either physical abuse or emotional abuse or sexual abuse. And the thing is, a child will not experience physical abuse where it's not accompanied an experience. They're not minding them, their needs are not being met. The children who don't have the basic needs met for them. And of the 3, the abuse, the neglect, and the household, the neglect has more impact because the abuse category has an element of neglect and the household category also has an element of neglect. Then you notice the household we have the child who is witnessing the mother being treated violently, and not just the mother now. We just can't talk about the mother without talking, because even now we have violence towards fathers, and also a child who is living in a household where they are also witnessing other children being abused or other family members being abused. As long as there is violence at home, then there's an element of neglect that comes with it. Because when parents are fighting, then they are not in the frame of mind to take care of the children. These children will be emotionally neglected. A family where there is a significant caregiver or family member who is also has a mental illness, that also becomes very difficult for these parents or these primary caregivers to take care of the child. Where there is an incarcerated parent, it comes with separation. It also comes with lack of a primary caregiver, and it is also highly correlated that children with parents who are incarcerated are more likely to end up in crime than children without a history of parental incarceration. Where children are living in a parent where the parents are alcoholic or the primary caregiver, or where there is a history of drug and substance use, that also becomes a trauma experience for the children. Why? The caregivers are using the money to meet their alcohol habits or drug habits. And as they are meeting their drug habits, there's a very high possibility there'll be violence in that home. So the children are witnessing violence. And there's also a very high likelihood that marriage will end up in separation and divorce, which is a trauma experience. And there's also a very high likelihood that there'll be some form of neglect. Why is this important for us? Because when we see children like we are going to see who have delinquent behavior, do we stop to ask ourselves, what's their family background like? Who is this child? Where are they coming from? What have they experienced? What would have pushed them to where they are? Because it's not normal that children will end up in crime. It's not a normal trajectory path for a child. It's also said that children with 4 of these, it's a score of 4 out of 10, they're more at risk of mental health illness than a child without that experience. A child with a trauma experience score of 5 and above is more at risk of suicide than any other child. So then, is it a surprise when we see the high number of young people who are committing suicide? We need to stop and ask ourselves, it's not just the child in court, it's not just the child in the justice system, it's who is this child and where are they coming from and what could have happened to them. So when a child is neglected physically and there is still a neighbor's hen, is that child a delinquent, or is it because they have a trauma experience of neglect? And this is the kind of assessment we need to do when we are working with children. There from fear in our country. What is it like that would push children into the justice system? Children who have medical trauma, they have chronic illnesses, they've had accidents, they've had surgeries, and what that means. You know, the natural disasters, like our children growing up in the, very dry areas. You're talking about school violence, where bullying is also part of the school violence. Then you're talking about children with traumatic grief. And COVID is one of those instances where we are seeing very many children now who've lost a family member. And the emphasis here is, can we do a very good assessment to understand who are these children and why are they in the justice system? Why is this understanding important? Because of children and their vulnerability, children don't take themselves to the police station to report. There has to be an adult who is leading the process. They don't bring themselves into my therapy room. There has to be someone who is going to report, who is going to recommend, who is going to accompany the child. If we understand childhood trauma, then it will reduce the number of undetected cases of children with trauma experiences. It will increase the reported cases, because when cases are reported, then children will get, whether it's treatment or whether it's whatever form of support that the children need. So we all now become people who are sensitized into, let's be people who can detect, let's empower children to talk about it. In our interaction with children, let's ensure that we have higher numbers of reported cases, because it's only when these trauma cases are reported that the children can get the support that they need. What do we need to consider as workers in the justice system or players? We need to understand this justice flow, or the journey that the child walks when they enter the justice system. We have the first responder. This is the person, for example, like in the case of sexual assault or whatever form of abuse, even neglect. There's always this one person who gets to be told first. Who is this person? What do they know about children and trauma? What kind of intervention do they do? And the saddest reality is that children with trauma experiences in the justice system, all the 5 steps are actual trauma spots for this child. Because this child will tell a teacher, the teacher will tell the head teacher will tell someone else. And this child will start by repeating this story. How many times is this child going to repeat their story? At the first responder point, they have told one person, then like if it is in school, the teacher says, come and tell the head teacher. Then the head teacher says, come and tell someone else. Come and repeat the same story. And what are we doing? We are not helping, we are not intervening, we are actually making the child repeat their story, which borders on re-traumatizing this child. They move on to the second step. How many times is the child going to tell the story at the police station, or at the medical, or at the hospital? They go to the police station and the police station says, no, you need to go to the hospital. They repeat the same story. with the doctor. So in the event it's a child who is sexually assaulted, then this doctor is going to carry out an invasive procedure. Let's assume it was a sexual assault for a girl or a boy. How do they collect the DNA evidence? They will have to be invasive. Does this doctor prepare the child for what they're about to do? Or do they just like go lie down and, you know, let me examine you? And then the child is actually made re-traumatized at the responder point. Do we have just one police officer at the child protection unit that the child tells the story and so that they don't have to tell that story again? And then they meet the pre-trial, they get to the pre-trial phase. They have to repeat the same story. I want you to put yourself in the shoes of this child. I already have a neglect experience. I'm already feeling rejected. I'm already feeling unwanted. How many times do you want me to keep saying this story? How many prosecutors? Before the matter is concluded, the prosecutor is transferred. What will the next prosecutor do? Come and tell us the story all over again. And then they come to court. And when this child comes to court, in the event it was the case of an abuser, then they meet the abuser face to face. How well is this child prepared for their encounter with the abuser? Is it then no wonder that when this child faces the abuser in court, they freeze? They never had them who is walking with them, who is encouraging them, and yet they will meet them. What kind of questions is the defense counsel asking about asking this child? Are we taking into consideration where they are coming from and what they have gone through? And the court, just right there, becomes a trauma spot. And then the reintegration. What is it that informs the reintegration process? What informs what the child officer, the children officer is going to write to recommend, or the probation officer? As the magistrate is giving that court order that this child needs to be moved from that environment and taken to a children's home, because we think this is a case of protection and care. Have we stopped to ask this child, what are your unsustainable wishes? What do you really want? We don't do that. Then what can we say determines justice for this child? If it is a child who is in conflict with the law, then let's look at that flow again. Who is the first responder? How do they see this child? They've already given them the label, you're a criminal, when you come kora, you know, kind of a label. What happens at the second responder step or stage? Do they stop to ask, why did you burn the books in school? Why did you steal? Why did you do what you did? Is that part of the history that is taken about, or information that is collected about this child? What about the prosecutor? When do we determine when it is diversion? What informs diversion? How do we ensure that even if they transition through the justice system, that at the end of the day, all the basic needs of the child are met? So when we are sending a child to a juvenile institution, have we stopped to ask ourselves, is that justice? Is that committing this child to this juvenile institution? Is it addressing the primary reasons why the child entered in the justice system in the first place? So as we are talking about justice, let's ask ourselves, what is justice in the eyes of the child, not even in the justice system? So what does trauma do? It's important for us to appreciate that any trauma experience for a child, if it happens especially below the age of 5, that 90% of the child's brain development happens below the age of 5. So if trauma happens below the age of 5, then this basically means for us that the child's brain development will not reach full maturity or will not develop the same way as a child who who doesn't have a trauma experience. Why is this important for us? Because then there are two types of ages when we are talking about children. There's the chronological age, that is the calendar age or the developmental age, January to December, 10 years. But there is the mental age. And the mental age will stop at the trauma point. So you can have a child who is 14 years, but in actual sense, their mental development is 6, because that's when the trauma happened. So what does this mean? That this child, even in terms of academic, they will never be at the same level with the other children. What does this also mean? That in our interaction with this child, even the questioning, you think it's a 14-year-old, but mentally, you're actually dealing with a 6-year-old. So even the kind of questions you're asking this child, they will not comprehend. They will not give you the responses. The analysis you want them to have, they will not have it, because that's not where they are. Then we are saying we have a hostile witness. Is it really a hostile witness? Or is it because this child has something or something happened to them? What does trauma do? So when you're looking for the kind of information, like words, like images, like sounds, in the child witness or in the child's testimony, trauma has a way of impacting that information. So when you want them to remember those faces, when you want them to remember what did they tell you, because trauma is so impacting and so overwhelming for the child, then the system, the brain automatically decides for the child what is important for them to pick and what is not important. What does this mean? Their narration of the story may have gaps. Pieces and bits of information, very important, could be missing. What does it also mean? This episodic memory or the autobiographical memory, which is very, very, very important. And it includes who did it, what happened, where did it happen, when did it happen? So when you are asking the child to give you information like what time was it, we have to remember children may not necessarily remember that, especially if they have a trauma experience. When you're saying, do you remember the face? They may not pick that face because their system was so overwhelmed and the system decided what is important. What else is happening to this child? Then you have this child who sees this abuser, or who just sees one trigger in the court. It could be something I was wearing or you are wearing. It could be a sound. It could be something they see in that courtroom that becomes a trigger of the trauma experience. What happens to them? They freeze. They begin to cry. You begin, they are there. They're not talking. They're very unresponsive. Is it because the child is hostile? No. They've just seen something that has triggered their emotional memory and has sent them back to that trauma experience. And right now in their frame of mind, it's not about the questions you're asking. It's about the trauma images that are replaying. What else happens to them? They lose some of the skills they had acquired before. So what are we saying? If you do a good assessment of this child, you will notice the teachers now will tell us they have regressed. The mother will say they're scared, they're bedwetting, things they could do before, they can't do them now. Is it because they are just children who are just being difficult? No. We need to ask ourselves what exactly happened to those children. And then children with trauma experiences as a way of coping. Remember, especially in the case of abuse, it's about power and control. Because they are vulnerable as children, they don't have the capacity to speak for themselves or to, hit back at whoever caused them the trauma. Then they begin to manifest behavior that, according to us in the justice system, look like problem behaviors. So the children who are being brought to court because they are aggressive or there's aggression to people and the animals, they are bullying, they are fighting, they are stealing, there is coerced sexual activity, the children who are cruel to animals. Is it really they're just problematic children, or is it their way of dealing with what happened to them? Those who are destroying, this destruction of property. And I know this is one of the things that children will be charged with. They've burnt books, they've destroyed lockers and desks and things in school. They've set things on fire. They're deliberately destroying the neighbor's property or other things, or even at home. Is it normal for a child to pick things and destroy? No, it's their way of dealing with what is happening in them. They are violating rules. Truancy, they are running away from home, they are running away from school. Is there a possibility that the home or the school or whatever institution is the trauma spot for that child? And that's where they are getting their trauma from, or that is where the abuse is coming from. And as we work with these children and we are seeking justice and we are seeking to understand justice through the eyes of the child, then we need to ask ourselves, what does the law say about child vulnerability? What is it that the child says, that the law is saying? One of the things that is missing, and I know it is there, especially in the Sexual Offences Act, there's such a thing as court-mandated therapy. One of the things that we are missing in justice with children is this coordinated mode-sectoral approach, where we have the child right in the middle, and we have everyone working for the benefit of this child. What are we saying? That these children require, when they enter the system, at the beginning of the first contact point, we need to be thinking about the aftercare and the reintegration, but not wait at step 5. It needs to be through care. We are talking about through care, not at the end. We need to have a justice system that is responsive to the needs of the children, that understands who is a child uniquely, singularly, and what are the needs of this child, so that even as the child goes through the justice system, the end, the reintegration and the aftercare is extremely important for us to remember at the very beginning. Then we also need to ask ourselves, because reintegration is very important, where is the family? What is the role of the family? Who is this child? Where are they coming from? What kind of support system do they have at the family? So that if the family is the trigger, we need to do something about this child because their basic needs must be met. How do we reunite this child with the family at the end? Because we are also talking about deinstitutionalizing children. What are some of the services that need to be offered through care? Where is the court-mandated therapy? If these children at the first contact point were referred to a child therapist, by the time the pre-trial phase is coming, this child is ready for trial. This child is ready to appear stage 4 in court and meet the honorable magistrate. This child will not be intimidated. This child will not freeze. This child will be ready. By the time we are reintegrating this child at step 5, we have listened to this child because there is child participation. We have identified the ascertainable wishes of this child. We know what is in the best interest of the child. And that begs the question, what really do we mean when we talk about in the best interest of the child? And it is true, children going through the justice system is a traumatic experience in itself, first and foremost. Now, that's one. Number 2, there's a very high likelihood they have a trauma experience, the ones we have seen. And then number 3, if these children don't get appropriate intervention, then you can be sure we are more likely to find them in the adult juvenile institution if they're not going to end up with mental illnesses. When it's time now, we come together, all of us, and have the best interest of the child and have the child in the middle of this helping system. What are we also saying? Children should be seen, but they need to be heard. Not to be seen and not heard. We need to involve children. We need to listen to them. We need to believe the child experiences. And if the justice system is going to be a fair and just system for the child, I can tell you, Honorable Gitanga, you need to work with the child therapist. This child will be ready, will be prepared. You will have a better child who can talk to you confidently because they have not only dealt with the trauma, they have reconciled with it, and then they are ready enough. So let's learn to listen to children. And most importantly, let us remember that children are like wet cement. Whatever touches them leaves a permanent imprint. So if you are defense counsel, you touch them. What imprint are we leaving? If I'm a child therapist, what imprint? If I'm a prosecutor, what imprint? We need to ask ourselves, in my interaction with the child, is it in the best interest of this child? Because they are like wet cement. Thank you very much, and back to you.
Thank you so much. Thank you so much, Ms. Njihia. Thank you so much.
Joy?
Thank you so much. Can you hear me? So thank you so much, Ms. Njihia, for that beautiful presentation. I want to present just two questions. There's one of our followers who asks, does exposure to violent media form part of the adverse childhood trauma? Does exposure to violent media form part of adverse childhood trauma? To you, Ms. Njihia. Hello. Ms. Njihia, can you hear me? Ms. Njihia, can you hear me?
I can hear you now. Sorry, I couldn't hear you before.
I'm also having some technological hitches.
Yeah.
There's a question that was shared by one of our followers.
Mhm.
Does exposure to violent media form part of the adverse childhood trauma?
And my answer would be yes, because then again, for the child, it's exposure to that violence. And you see the thing about any exposure to violence for the child, remember, because their brain development has not reached full maturity until the age of 25. The child has trouble just trying to separate that what they are seeing on social media, even if it is a movie, is not real. For them, everything that children, especially at younger ages, see is real. And so if there is too much of it that they are seeing on a continuous basis, then children pick it, that it is real, that is what is happening. And again, that explains why sometimes you see children are going to be dreaming with content material that they are watching on TV or whatever other social media, because for them it's real. It's not acting, it's real.
Thank you so much for that response. Another follower asked whether social media violence can form part of childhood trauma, whatever we see on social media.
Again, I'll go back and say that yes, it is true, because remember, these children, their brain development, and especially that part of the brain that is responsible for decision-making, critical thinking, assessment, and analysis, doesn't mature full maturity until age of 25. So as long as they have constant exposure to what they are seeing, the more they see it, the more they believe that it is true. Because after all, if it wasn't, this content would just be replayed over and over and over again. And that is why we always, it's recommended, is it child appropriate material or child appropriate content? And that's why you have all those disclaimers, because children are not little adults. And we need to treat children as children and not little adults who have the same understanding as adults. So exposure to it, yes, it will actually traumatize them. Yes.
Thank you so much for that response. I'm having some technological hitches as well, which will be sorted before the next presentation. Thank you for your feedback. Mary Sheila, who keeps emphasizing on the need for multi-sectoral approach when dealing with child-related cases. So allow me to move to the next presenter, who is Honorable Jehad Gitonga. So briefly, I'll take you through his bio. So Honorable Jehad Gitonga is currently in charge of the Milimani Children's Court. He attained his undergraduate degree in law from the Makerere University. He graduated with his LLM from the University of Nairobi and is currently pursuing his doctorate. Honorable Gitonga was recently promoted to become the principal magistrate and is adept with children matters. So with that brief introduction, allow me to welcome Honorable Gitonga to share with us this afternoon. Karibu sana.
Thank you, Madam Joy. Good afternoon, participants. I am delighted to be with you this afternoon. Every time I keep saying, every time I get an opportunity to share with us matters dealing with children, I'm happy because we get opportunities to learn more. We get opportunities to share experiences, and we also get opportunities to appreciate the reasoning behind some of the determinations we make and the philosophies underpinning them. Now, if Joy, you will allow me to just say one aspect of, as part of my introduction, I have been at the Children's Court for the last 5 years now. I've been very fortunate to deal with children cases. I have gotten my own experience, and every time I sit to make a determination on a matter dealing with the welfare of the children, I get influenced by 3 aspects of my life. Number 1, I apply the law to the best of my understanding. Number 2, I am also a family person. I am a father, I am a husband. And when I'm sitting to make a determination on an issue dealing with children, I always try to wear the shoes of the parent. And of course, imagine my own children in the picture. I have 2 daughters and 1 son, and I'm happy to sit in this kind of setting as a court because I draw experiences every day. And number 3, I also approach these matters from an African value system because when we were growing up in the early 80s, the African approach to the child is that the child is a delicate property of a community. A child does not just belong to the mother and father. They are more stakeholders in the child's life. And every time then I have an opportunity to address myself to an issue dealing with a child, I approach it from that collective community approach. Now, I've been invited to speak to the topic of justice in the eyes of the child. And because I sit in court, I have narrowed myself down to the issue of how children have faced trauma. I mean, how children who have faced trauma are handled within the justice system. So this is an experience we are sharing on our day-to-day operations in court. I'm going to make my presentation in 3 phases, and I apologize that I'm not doing any PowerPoint presentation, but I'll try to be slow enough so that the listeners can be able to appreciate the content. The first phase of my presentation is looking at how the children get into the justice system in the first place. I already appreciate, of course, what the presenter went before me, Madam Njihia. She has taken us through a very, very informative stage of our discussion today. And I want to pick up right from where she stopped and ask ourselves, how do the children then get into the justice system? Looking at the law, one of the ways by which children will find themselves in the legal system is when child is in conflict with the law, which we also call child offenders. That is one entry point into the justice system as child offenders. The other way is as children who are in need of care and protection. And when I was going through the presentation, my good friend, Madam Jia, was making, and when she was addressing some of the trauma, I realized that a number of them may actually fall very much squarely on what we call Section 119 of the Children Act, instances of how a child becomes a child in need of care and protection. For example, a child who is neglected, a child who is found to be begging, for example, in the streets, automatically becomes a child in need of care and protection. A child with no parent or guardians who has been abandoned by his parents or guardians becomes a child in need of care and protection, which in my view and from the learning we've just had would itself constitute some form of trauma because they are suffering. A child whose parent or guardian has been imprisoned and therefore they've been left without anyone to attend to them. So that Section 119 gives you a whole list, including a child who has experienced domestic violence, a child who is threatened with female genital mutilation, for example. It's a whole list of instances where a child might find themselves in the justice system by reason of being a child in need of care and protection. Similarly, a child may find themselves in our system as courts, as victims of either domestic violence or sexual abuses. And in this respect, they will be coming in as, we call them either victim stroke complainant. The other instance in which a child may find themselves is, of course, as a witness of either violence or sexual abuse. So those are the entry points that we are looking at as a court. And If you allow me to use the language of the law, you will see that the court's jurisdiction is going to be invoked at any one of those entry points, whether need of care and protection, whether as a child in conflict with the law, whether as a child who is coming in as a witness, either in a own abuse or having witnessed, let's say, domestic violence, for example, a fight between mom and dad. So those are the instances. Of course, we also do have other cases where, and those form the bulk of the court work, cases where parents have fallen out, and you saw the presenter who went before me mentioning about divorce and the trauma that comes with it. Ordinarily, separation or divorce also leads to the other issues of child custody and maintenance. It is never easy for a child to have to pick between staying with mom or staying with dad in the event of separation. So those are the entry points we are looking at. And what follows now, the second phase of my presentation, is the legal safeguards. And while I'm looking at the legal safeguards, I will also be looking at the systemic failures. And then the final part of it, I'll look at how do we then collectively address those systemic failures. And I need to mention that a child by their very nature is a vulnerable person. The law has trying to do much to protect the child by reason of vulnerability, because it is recognized that if left to their own devices, a child is not likely to survive. Now, if you're going to look at the law in terms of the legal safeguards that are in place, I think the first port of call would be Article 53, Subarticle 2, which captures the constitutional principle of the child's best interest. And I think you've heard the clinical psychologist make mention of the best interest of the child. I would say it is usually the clarion call to any person dealing with the matters touching on the welfare of the child. The beginning point is always the question of, is the child's best interest being met? And I'll give an example. Ordinarily, when parties fall out, when they come to court, the tendency is always to seek to assert their rights. The mother will be saying that I am the biological mother, I therefore should be given this and that in terms of custody. And the father says the same. Now, the court as an arbiter is called upon to rise above those interests and only ask that question, where is the best interest of the child likely to be met if I make this kind of order? So the first safeguard would be Article 53, Subarticle 2 of the Constitution. Now, with regard to the children in conflict with the law, over and above the safeguards that are accorded to a normal accused person under Article 50 of the Constitution, the law has been also tailored to accommodate the vulnerability of a child by coming up with what we call the child offender rules. Now, the child offender rules are to be found at the 5th schedule of the Children Act. And they prescribe a number of normatives of what should be done. The offender rules will say, for example, when a child is taken to a police station on allegations that they have committed an offense. And remember, these offenses may vary from picking some mango on their way from school at a neighbor's land or farm, or assaulting another child in school. All those various instances, as you can imagine, a child would be involved in. The child offender rules say that the first thing at the desk of the Child Protection Unit at a police station, the officer manning that station, or rather that desk, would be expected to first contact the guardian or the parent of that child. That is a legal safeguard under the child offender rules. As to whether that is what obtains is a question we shall be addressing in terms of the systemic failures. The same rules will also say that a child charged at the magistrate's court shall be processed through the legal system within 3 months. And if those 3 months then elapse without the matter having concluded, then the rules say that the child shall stand discharged and not to be charged over the same matter. Again, as to whether this happens in our real court is a question to be addressed as a systemic failure. Now, the other safeguard you will find under the children, under the same child offender rules, is the requirement for the proceedings to be undertaken in camera. Now, in simple language, camera means a court retreating, for example, either in chambers or asking members of the public to leave the courtroom to clear the court for the court to hear a matter touching on a child. That is a legal safeguard because of the vulnerability of the child. The other safeguard is to be found under the Sexual Offences Act. If you look at section 31, it contains a number of categories of persons who are deemed to be vulnerable witnesses. And one of the vulnerability tests is a test of age, and a child falls under that. Meaning to say that when you have a case where a child is coming in as a victim and therefore a witness in our own trauma, then the law allows the child to testify through an intermediary. This is a person who will, as much as the circumstances can permit, give evidence of an account of what happened to the child, but without testifying as a witness themselves. You will, if you go back to our first presentation, you remember Ms. Nje here was touching on the memories, episodic memories and the others. Oftentimes, as we sit in the court, a child who has introduced themselves very well, said they're in a school somewhere, they're in grade 5, blah, 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 they will suddenly just stop. What happens if you get an overzealous defense counsel, and I'm saying that with respect, is that they're likely to say that, seek to make all manner of applications that, this is an incompetent witness, could very well be, hostile, all that. And that is why we have the safeguard of section 31 that allows a child to give an account of what happened through another person who the law calls an intermediary. So that is yet another legal safeguard. Again, going back to the child offender rules, they state that if a child is to be detained, whether through a court order or even at the very preliminary stage at the police station, then they should be detained in separate cells from adults, and they equally should be detained in separate cells in terms of gender. Now, you and I know, and we have read on different occasions, instances where they are even abused at the police station. When they thought they were running to safety, and the very person who is meant to provide that safety turns to be the tormentor. So those are the systemic failures we are talking about. And my submission is that it is not like we lack the legal safeguards. In fact, if we were to follow the letter and spirit of the law, right from the Constitution, right from the Sexual Offences Act, through the Children Act and the accompanying child offender rules, there is a possibility that we can deliver a very child-friendly justice system within the obtaining legal regime. However, and of course, there's a requirement again that even when held in custody, it must not be beyond the 24 hours. So I've just given a nutshell of the legal safeguards. You will permit me to look very quickly at the systemic failures. Because what happens in real life is that if, for example, we are focusing on the child offenders, all the safeguards I've given are oftentimes flouted. The court is guilty, and I'm embarrassed to say that, because if you came here and took stock of the matters we have, you are likely to find matters where, of course, a case is 2019, a case is 2020, a case is 2018, meaning to say that if you were to apply now the child offender rules in the strict sense of it, then all those cases, the subjects involved, the children involved in those cases should actually stand discharged. But I will pick something that the presenter who was there before me stated, that one of the problems she identified was lack of coordination by the different players in the system. Because if we don't have a system, and this is some of the things we try to address through the National Council for the Administration of Justice, which has basically all the players. If, for example, a child will be presented before court, and then we go back now to gather evidence, inevitably we are likely to fail the child by reason of not presenting the evidence within the reasonable time. Equally, if the court will adjourn unnecessarily, we are not likely to meet the 3 months threshold that the law gives us. So the bulk of the issues that affect the justice system when dealing with the children who are in it, of course, by reason of the trauma we have addressed, is that unless and until when we learn to coordinate from the moment a crime, an offense is detected, to the moment someone is presented in court, to the availability of counsel, because remember, if we are talking of children offenders, then the law says that they must have legal representation at the expense of the state. And therefore, that in itself, if not well coordinated, could prove difficult, because you have a child who is presented today. We have not made arrangements to appoint a pro bono counsel to act for the child. We are having to adjourn, for example, for another 1 week as we arrange to have counsel. That 1 week spent by a child in any form of detention is likely to leave that child much worse than they were at the point when the alleged crime was committed. Equally, when the court is about to make an order for, let's say, we have gone through the court process. We are now at the stage of sentencing. Remember, again, the law is clear on the kind of recommendations the court can make, whether to commit them to, a responsible person, whether to commit them to a boarding institution or a children's home. The court will require, for example, the services of a probation officer. But if that probation officer is not fully capacitated in terms of resources, then instead of taking 3 days to file a report, they're most likely going to take possibly even 3 weeks. And the court does not have much options, especially in Nairobi. And I'm saying Nairobi because Nairobi is a jurisdiction which has peculiar circumstances. When a court is not having a proper history of the subject, the child is coming from an informal settlement. We do not have a background of where the parents are. If we just release that child on free bond, then again, we are getting stuck in terms of the case progressing. So there are a couple of systemic failures that militate against the proper application of the safeguards of the law that are intended to ensure that the child is not re-traumatized, as the psychologist was saying. You will allow me to go to the last aspect of my presentation, which is basically to try and see whether we can have ways in which we can address the failures. And I make a case for the training of the police, the training of the prosecutors, the training of the magistrates, and the lawyers, and here I mean the defense counsel, on child-friendly and gender-sensitive justice approaches. Because if all of us are on the same page, appreciating very well that this is, no matter the offense, where the person charged is a child, we must learn to look at that case through the prism of a child. And that is why we are saying that, and I appreciate when the earlier presenter said that it is not so much about justice. It is what justice means in the eyes of the child. Because you and I can throw a lot of legal jargons. You can even appear as amicus curiae, all those things that we love using in court. But where is the child in that matrix? And that's why I'm making a case for training, because when we are sensitized on the need for each one of us to play their role and play it well, then we are likely to root out the systemic failure, and we're likely to deliver justice, not only in our own views, but through the eyes of the child. Number two, I make a case for the keeping the children away from the formal criminal justice system through diversion and alternative dispute resolution mechanisms. The world over, and if you look at the record, it has been acknowledged that justice systems have not been able to fully deliver justice and the rights of the child in an efficient way. This has nothing to do with being in a developing country. It is an acknowledgement that justice systems are always prone to failure. Because our courts deal with the facts, not truth. So the way facts are presented is the way justice is likely to respond. And that's why we are saying that, having recognized the fact that it is possible to take a child through the justice system, and at the end of it, at the tail end of the process, you have actually made that child much hardened If you meet them out there in the street, they say, Mimi hata nililala ndani siku 10. What do you think you can do to me? Because you see, to them, they harden as the situations harden when they have no way of getting themselves out. So that's why we are saying that for us to be able to deliver justice in the eyes that the child would appreciate and make them that rather than break them, then we make a case for pitching for alternative dispute resolution mechanisms by way of promoting diversion, by way of having approaches of restorative justice, where, for example, you bring both the victim and the subject or the offender to the same table and finding a solution that is in the best interest of the child. In the course of our duty as we sit here, we normally will have those cases where children have even fought in school. Of course, a fighting may not end well. You might even have one child sustaining a more grievous injury as against the other. Obviously, it makes the school will hand over the case to the police and the justice system will be triggered. And when we have the subject, the child offender in the court, we have the complainant as his classmate. And the question that the stakeholders should be asking is whether we really need to have that case in court. And that's why we are saying that as we grapple with the systemic failures, can we be wiser to pitch for alternative dispute resolution mechanisms to cushion the children against the trauma occasioned by the system? That is what we are talking about. Now, the other recommendation I would make is advancing alternatives to both pre-trial and also post-trial detention. By limiting the time which is spent either at the police station when the child is taken there. You remember we are saying that the law would talks of 24 hours, but ordinarily it is not the case. And even when they bring in within those 24 hours, in fact, the tendency is to come and seek leave from court to have the child or the offender detained for much longer, for 7 days, 14 days and the like. If we are all alert to the effect this is likely to cause to the child, then we would be diligent enough to apply ourselves to the law and play our part and ensure that we do not hold the child unnecessarily. This also would apply to the court. A court which is properly trained and sensitized will always be very keen on looking for alternative ways of minimizing the duration of time, whether at the post-trial, that a child should be in a remand custody. Even, and I say that because I know we take them to Kamai and these other places, even when we are taking them there, the inclination should be to foster family reintegration than to place them in a home. So I think that is how I would look at it. You will permit me to conclude by saying that an overall appraisal of the legal system in terms of dealing with the children cases leaves a lot to be desired. I've identified those areas that I feel that much would be done for us to be able to say with the confidence that we have delivered justice as desired by a child. And these gaps can only be closed if we are able to coordinate and work together and always place the best interest of the child at the forefront of all considerations. Thank you, and I will beg to stop at this point.
Thank you so much, Honorable Kitonga, for the wonderful presentation. A lot of emphasis has been laid on the best interest of the child by our first presenter, Margaret Terry. Honorable Gitonga has gone further to emphasize that there are legal provisions under Article 53 of our Kenyan Constitution that still emphasizes on the need for the best interest of the child. Looking at our chat box, participants continue to echo the need to have those coordinated efforts within the system to ensure that the child is supported overally. And Honorable Gitonga has left us with 4 recommendations. In as much as he's cited the gaps that lay there, the systematic failures and challenges, there are 3 things that he's highlighted that I'd like to repeat. There's need for capacity building, which is basically training for for police, prosecutors, magistrates, and the lawyers as well on gender sensitivity and child-friendly approaches. The second recommendation from Honorable Gitonga was the need to embrace diversion and ADR in children cases. Then the last recommendation was there should be an alternative to pretrial and post-trial detention, especially at the police station. I've seen several comments on the chat asking whether someone was asking, are there circumstances that can lead a child to be kept together with adults in a cell? Before I ask Honorable Gitonga to respond to that, I'd still go back to his presentation where he was categorical about the systematic failures. The law is clear that this shouldn't happen, but he again highlighted that this is still happening. So back to you, Honorable Gitonga, are there other specific instances where a child, this is anyone under 18, can be kept in the same cells as an adult? And also Eunice Majuma, to answer the same question, says very well said, but our children are here sharing the police cells with adult offenders. What do we do? The whole issue on children sharing cells with offenders has been highlighted. I even got a private message, someone telling me about children who are taken to police stations in need of care and protection. These are lost children, and they end up bundled together in very, for lack of a better word, very dirty cells where honestly the best interest of that child is not at heart. So what do you have to say, Honorable Gitonga?
Thank you, Madam Joy, for that, and I thank you also for the person who is asking that question out of concern. And you realize it's it's not just one person. I think it is something happening most of the places, and I will say there cannot be any legal holding of a child in the same cell with an adult. It is an illegality. And yet it happens. In fact, that is why we said that we do appreciate the systematic failures, and there's a lot that needs to be done in terms of both capacity building, because I could draw 2 hypotheses in a scenario where a child is placed in the same cell with an adult. My first hypothesis is that either the officer who is manning the child protection unit at that particular station is not well versed with the child offender rules. That is the first hypothesis. The second one is that they have no infrastructural capacity to hold the 2 in separate cells. And oftentimes those 2 hypotheses would be right. So, and that's why I'm saying that we need first to, of course, there's also the channeling of resources, because, and I know my good brother, Mr. Kimani, the Assistant Director of Children's Services, Nairobi, will be coming to make his presentation. I've always agonized, and I am making this comment, presumably with his permission. I always wonder how the children officers survive with very limited budget, and yet they have to crisscross these counties, making reports to be presented in court. And that aspect of resources might well be the concern even at the police station. So there is the sensitization. There is also the aspect of capacity building in terms of resources.
Thank you so much for that response. Just to pick a few comments from the presentation on our chat box. We have the same issue on cells being repeated. Siandra P says that's a good presentation. Venerable Gitonga, we need to get this information out there to the masses, especially the child offender roles. I couldn't agree more, Ms. Sian. We also have Chris, who's this? Someone asking whether we could have this recording access. It's been streamed live on our Facebook page. You can always follow us and get access to the same. Mwangi says it is recommended that when you're introducing children to justice system, you make use of forensic interviewing. How much of this is used in juvenile system in Kenya? I believe that question goes to Honorable Gitonga. Then before he responds to that, Sandy K says, as we discussed this, there's need to reevaluate and implement the recommendations for the Special Task Force on Children Matters, the status report on children in the justice system, and fully implement diversion as a mechanism in the child justice system. Over to you, Honorable Gitonga.
Yes, I associate myself with those recent comments about looking at the status report and also making use of diversion. I think the report in a big way does give us a starting point. And if it were to be accompanied with the required resources, then I think we, and I need to assure some of the participants in this sense, in the sense that the children court and the persons who man the court, and that includes myself, we are always very sensitive. In fact, when you come here and you start sitting and hearing the children cases, even if originally you were not inclined so much to address the welfare of the children, you get converted along the way. So the courts are always usually very keen to ensure that we deliver within possibly the required time. However, because of the challenges we have, like as you see me here, I'm in charge of the administrative function of this court. We are 6 of our colleagues, but the advocates who, a number of them whom I know are following this now, will tell you that the kind of cases that are filed on each day, they're overwhelming. However, if we were fully capacitated and we are able now to go the extra mile, sometimes you will find us here sitting up to around 5 in the evening. And I'm saying that with confidence because I know those who appear in my court know that. So we have the zeal, we have the determination, and we have the drive. But what you will find is that there are those other things that you will not be able to accomplish however much you want, because again, you are not just the only player. One of the cases, and I'm sorry now I know this is not part of what I was seeking to address, but one of the biggest challenges we have had since the coronavirus is that most of the criminal cases in our court have not been able to take off. Why? Because there's a child who had been given a bond sometimes in 2019. The investigating officer tells you that we have not seen this child. They used to live in Kibera. We are now told they're in a village somewhere in Western. I'm highlighting that because when we do not have proper records, we are not even able to keep track of where the subjects go to, even when you release them on bond. Now, I wanted to address very quickly in 1 minute the question raised about whether we are able to use the forensics. I will say as we speak, we are very limited in terms of technological advancement, in terms of presenting evidence. If you will remember the presentation that was made by Madam J here, one of the issues she raised was the possibility of re-traumatizing the child by having the child telling the same story from the first responder to the second, to the DPP, to the court and the like. Ordinarily, if you were to have full capacity, you would have a scenario where evidence is recorded in the first instance when the traumatic event happens. That evidence is preserved in a manner that would allow it to ultimately find its way in a court of law without not having to be retold to various persons along the way. Now, if we were to reach that step, then I believe we will be more efficient and we will now be delivering justice in the eyes of the child as we are discussing today.
Very well. Thank you so much for that response. I believe the person who raised that question, I believe Mr. Mwangi, that has been sufficiently addressed. Our first and second presenter have been emphasizing on basically two things: the need for coordinated efforts and also the best interest of the child. Madam Maggie here mentioned about the child being involved in it, that to be not only to be seen, but also to be heard. All these things, if you are listening to both presenters, you'll find that they are more or less interrelated. So after listening to our child psychologist, we've listened to Honorable Gitonga. I want us to shift to the people, the person, the entity where children matters are vested. This is the Department of Children's Services, which is under, it's actually the Directorate, currently it's the Directorate of Children's Services under the Ministry of Labor and Social Protection. With us today, we have Mr. Ezekiel. Mr. Ezekiel Kimani is the Assistant Director, Nairobi County Children's Services. He holds a degree in Sociology and LLB. His workstation is at the Nairobi Children's Court. So he's been posted at the Nairobi Children's Court, that is Milimani, as a children officer. And a lot of reference has been made through and through. Ms. Margaret kept referring to the children officer's report. We had it again from Honorable Gitonga. So right now, allow me to welcome Mr. Ezekiel Kimani to come and tell us, how does he, as a children officer, what is justice through the eye of the child from where a children officer sits? So karibu sana, Ezekiel. We are waiting to hear from you.
Thank you so much, participants. I hope you can hear me. Well, I will begin my presentation by saying that children who get into the juvenile justice system are actually children who have been traumatized. And the Children Department is the government agency that has been bestowed with the responsibility of actually safeguarding the rights of the children. It is the government agency that looks at the issues and welfare of the children. It has been properly stated that our department is domiciled in the Ministry of Labor and Social Protection. And one of our mandates is actually to rescue children who are in either traumatic situations, those children who are in conflict with the law, and another category of children we call children in need of care and protection. So the department runs some institutions that normally houses or places the rescued children. Now, like in Nairobi, we have remand homes, we have a rescue center, and we also have a rehabilitation school. So these institutions set up, they have been set up to try and rehabilitate, to rescue those children, and by extension to safeguard their rights. So I also need to mention from the outset that these institutions are funded by the government, as you know, because we are a government agency and entity. And maybe the next question that we may need to ask ourselves is whether the care, whether how we handle those children in traumatic situations is actually the best way, given the fact that Honorable Gitonga has mentioned the inadequacy in the funding of the department. But basically, this is not a problem with the Department of Children alone. It is a problem that cuts across. The government has the responsibility of funding all those development projects. So we cannot say that the government can only channel its resources towards child protection. However, we also have other partners like private CCIs, who's also with the responsibility of child protection. So those agencies again have come up just to help us to take care of our children. So now maybe I've also been asked to mention or to take us through how we prepare reports and how we present them in court. That area I know has a lot of interest to members of the Law Society of Kenya, because a report touches on your client, and the content of that report is of course a great concern to you. So basically what we do, the first thing a litigant does or an advocate does is basically to serve us with the order to do the children officer's report. So when we are served with that order, then we seek to get the contact of the parties. So when we get the contact of the parties, we call them, we get in touch with them, ask them to present themselves for the interview in our office. Then later on, we go to the home visit and do home assessment. But I also need to add that we normally don't call the two parties together. We call, maybe we start with maybe the plaintiff. Then later on, we call the defendant. We hear them, and after we have interviewed them, then we go to their houses to do a home assessment. It is necessary for us to do a home visit, especially in cases where custody is being contested, because a home environment may have a bearing on the direction or on the decision of the court. So basically, that is how we come in to help the court in reaching a just determination. So after we have interviewed the parties and after we have carried out the home visit, then we retire to write the report. And we are guided by nothing but the best interest of the children. And you see the competing interest of the parties at times becomes just too much for us, because one party wants you to favor them, the other one wants you to favor them. So we try as much as possible to strike a balance. And by that I mean, this child belongs to the two parties. So in our recommendation to court that is not binding, we try to reach a balance. So for example, where the children are young, they are of tender age, of course, the law says that such children ought to be with their mother, absent exceptional circumstances. But we also do recognize that the father has a right that should not be limited. So we try to tell the court, look, here is a child, he's of tender years, and they should be with their mother. However, the father must as well be given unlimited access, because that way the parties will feel that justice has been done. Now, I was also asked to indicate how we file our reports in court. And before the advent of the virus, what we used to do, we were filing the report physically in court. But now, as you are aware, things have actually changed. So we normally file our reports in an email that is provided by the court. So the court assistant is supposed to now to print the report and file it in court physically. So basically, that is what we do. Maybe I may also need to mention that as child protection officers or as the duty bearers in the issue of protecting children, there is a certain level of safeguard that is required of us while handling these children, because children are sensitive and they are vulnerable. So as a matter of fact, we are supposed actually to handle them with the sensitivity that it deserves. Even in the custodial cases, the children are also traumatized, given the fact that the separation and divorce at times is very acrimonious. The children become traumatized. So how do we handle such children? We actually try to go down their level with a view to confronting them, and with a view to getting information from them in a manner that may not re-traumatize them. But even having said that, we also faced with a challenge, because where you are supposed to get the sustainable wish of the child, insofar as their preferred place of residence is concerned, that issue or that question posed to a child who is very young could actually trigger the anger, and the child becomes re-traumatized. But having said that, we do try, we have techniques of how best we get information from these children, with a view to getting information that is both useful to court and information that will now not leave the children being traumatized. Now, having said that, I wish to stop there and hand over the program to the organizers.
Thank you so much, Mr. Ezekiel Kimani from the Directorate of Children's Services. He's taken us through the process from how they do the reports to how they interview the parties, trying to always maintain the best interest of the child. He cited the challenges that they face as children officers, with each party pulling to their side. But again, the holding blue remains the best interest of the child. He mentioned again about, when he began his speech, he talked about the children that went through the juvenile system are children who've been traumatized. I look this back to Margaret Terry's introduction when she began her presentation. She mentioned about the three abuses: there's physical, emotional, and sexual. And she said a child who's been sexually abused has definitely been emotionally abused. A child who's been physically abused has been sexually abused. All I'm trying to say is all the presentations from these speakers are intertwined. If you look at it from the best interest of the child, and again, I reiterate, coordination, if we work together, it's multi-sectoral. You put your side, I put my side. If you're the police, if you're the prosecution, if you are the defense counsel, bearing in mind the recommendations that have been given to have those trained, we'll have a system where the best interest of the child is actually looked at, and the needs of the child who's going through the juvenile system are addressed in a holistic way. So I'll go to the chat box and look at some of the questions that have been raised. So I believe this was going to Mr. Ezekiel Kimani. John Kimaku asks, what of the children in Nairobi streets? This I verily believe goes to Mr. Ezekiel Kimani. And John Kimaku wants to know, what is the state, the plight of those children who are in the streets rather. We call them street connected children because streets do not have children. Then Jay, he goes by the name.
Can you repeat the question?
Okay, the question is, what is the position when it comes to those children who are living in the street? These are the street connected children. Maybe you could address that first. Then, yeah, that alone on, before we go to the next question, maybe you could address the issue of children who are connected to the streets, street connected children. Over to you, Mr. Kimani.
Yes, children in the street is also part of our mandate. And what we are supposed to do is actually to rescue them, because children in the street are also children in need of care and protection within the meaning of Section 119 of the Children's Act. Now, the reason why we may not be able to clear them all in the street is because of the issue of resources. Resources is okay, that bit is a very big hindrance, because where do you take them? The issue of where do you take them? What are you going to do with them? However, having said that, there is a program ongoing now between our department and Nairobi Metropolitan Service, where we are targeting very young children in the street and rescuing them. We are taking them to Gitaduro. Gitaduro is a rehabilitation school. But again, the issue of also of capacity will have to arise, because Gitaduro is not a very big institution to feed all those children in the street. Maybe that is where maybe the private sector or the civil society may come in, where we partner with them. They do their part, we do our part, because I believe this is not a challenge that can be handled by the government alone.
There you have it. This is not a one-man show. Case management is bulky, because the whole thing we're discussing actually about involving various stakeholders is what we call the case management system. So it's about everyone pulling their role, pulling their side, doing what they're exactly supposed to do. So another question to you, Mr. Kimani, there was a question addressed to you where Wilfred, I'm not sure if it's Wilfred, but someone, Geo asked, what's the main consideration, or what are the main considerations when you're preparing the children officer's report? What do you take into account?
Well, the overriding consideration is nothing but the best interest of the child. That's my take. We look at the best interest of the child at that particular point in time. Okay, we also consider other issues, but the paramount consideration is actually the best interest. That is what drives us.
Again, you have it there. The best interest of the child cannot be repeated enough times. The best interest of the child is what is mainly considered, and cases differ, case to case basis. The way one case will be handled is not the same way the other one will be handled. But the bottom point is that the best interest of the child has to be considered. In Margaret's words, children have to be involved. They are not just there to be seen, but they need to be heard. So again, to our chat box, have actual court affected how evidence by children is presented to court? I believe this is going to Honorable Gitonga, coming in a bit late, but we could have Honorable Gitonga's view on this. Has the virtual courts affected how evidence by children is presented to court? Kindly unmute yourself, Honorable Gitonga.
Yes, Madam Bujoy, I'm doing that. I hope I'm audible now. Yes, I will say yes, it has. It has because you will remember from the time we had the outbreak of COVID, that was last year in March. Everyone was actually confused in terms of how the systems, and this is not just about the court, but everywhere, how we were going to adopt the new normal. So for the courts, we first went off for throughout, I think, the month of the half month of March, that is from the 16th, all through to May. We were actually totally not proceeding. Then along the way, I think the Honorable, the then Chief Justice, Justice Maraga, realized that we had to do something to go back to court. Then we got directions now to partially reopen the courts. But even then, even before we could now agree on whether we could take a few cases for hearing, we had to now do a consultation of the court users. You must remember, for example, presentation of evidence takes different forms. There is a P3 form, for example, in the event of a sexual offense. There are treatment notes. There are those documents that need to be presented before court. And the question then was, how do we avail this evidence in a manner that does not prejudice the prosecution's case or even antagonize a fair trial? So I know I'm using so many words to explain, but the long and the short of it is that, yes, we have not been able to operate fully. Virtual proceedings are not the best for hearing. Remember, the law has a lot of safeguards in terms of, for example, when you were to look at Article 50, which provides now the safeguards for a fair trial. You know, the court must even satisfy itself that it has a way of observing the demeanor of a witness testifying. So if a witness is somewhere in Kibera in a virtual proceeding, and all I can see is some shadow, then it means we are not even able to proceed now with a hearing. So, and that's why I mentioned that criminal proceedings in matters where children are in conflict with the law have been very greatly affected by the COVID, because remember, an accused person who is represented can even choose to say that I only want my mother to proceed in open court, where number one, I can face the accuser, number two, I can be able to read the demeanor. So it is one area which has been very affected, especially because of the production of documents in the court. But we are again slowly now learning to see how we can, because we are also learning that COVID is likely to be much longer than we thought. So what we are trying now to embrace is an arrangement where the prosecution, for example, if it is a P3 form that can be sent through a court email well in advance of the hearing, then it is possible that if a copy placed before the court can be confirmed to be the original version with the prosecutor at the other end, then there's nothing to stop a trial. So I will say yes, but now we are trying to slowly adjust it to situations where we can be able to proceed.
Thank you. Thank you so much, Honorable Gitonga, for that comprehensive response to the query on whether the whole COVID situation has affected the way children tender their evidence in court. At this point, I request you drop out of this webinar and welcome my colleague Gloria to take over from me. Thank you so much.
Thank you so much to the speakers and moderator, Joy Madeka. Thank you so much for hosting us and having a very informative session. I can already confirm that change is happening in the background just by having these conversations. And I would really appreciate if you have any questions, feel free to drop us an email. We'll leave it in our chat box. And if you would like to maybe even reach out to Margaret Njihia, the counselor, for questions or even partnerships, it would be very advisable. As you can see, she's well versed in her area with children and the matters of counseling. So we really appreciate everything you've been able to gain and learn from this webinar. I'd like to invite maybe all speakers to just say a parting shot to our members, just to let them know what they would want to take away. The final thing, if they didn't hear anything else, what would you want them to know? Maybe you can start with you, Madam Margaret.
Thank you very much. My parting shots to all of us. First, let me say thank you for having me here. It's been a pleasure and an honor. I'm really humbled. My parting shot would be to all of us. When you're working with children, whether in conflict or in contact with the law, the burden we should carry is, number one, what is in the best interest of this child? Is what I think it is really in the best interest of this child. And when we are thinking about children and making determinations and whatever decisions we make and determinations, then we also need to remember, is it meeting the child's developmental needs? Is it fair? Is it just? Because if it is not just in the eyes of the child, then there is no justice. Thank you.
We hear you, we absolutely hear you. If the interests of the child are not considered when they're in court, be it that they're the victims or be it that they're the offenders, there will be no justice. As we've been told before, even when in cases where the child is the offender, most cases it's that they've been in cases of trauma. So we need to consider them before putting them in the justice system. Mr. Honorable Gitanga, would you want to say something?
Yes, thank you. Thank you. Two things very quickly. Number one, I do really appreciate the LSK Nairobi branch for the organization of the webinars. I think if there's anything better that happened with the COVID, it was for the Law Society Nairobi branch to step up and come up with this educative series. Personally, I am a scholar and I like following most of the discussions Unfortunately, sometimes by reason of my nature of work, I end up missing. But I do appreciate when I get a chance to participate like today. And I always leave the wiser, because when I get to hear what the presenter, who is a clinical psychologist, had to give us today, when I get to hear the experiences of my brother, Mr. Kimani, from the Department of Children Services, and when I get to hear the feedback from the other participants by way of the chats and also by the way of questions, we always go back and improve on what we are doing. That is one, and I appreciate you for that. Two, I will leave all of us with this message that the future of the world and the future of Kenya depends on how we treat our children. You and I might not be there in the next 40 years, unless if you are the biblical Methuselah, which I doubt that we are. So that we need to secure the future by treating our children well, whether they're in need of, whether they're in conflict with the law, whether they're in need of care and protection, or whether they are just at the comfort of our homes. Because we might think that the children who probably have mother and father staying together and they are, going to school and coming back, we might think that they do not need careful watching, but they do. So to me, I think, and it goes down to the way the law has been tailored, coming up with the best interest principle, coming up with issues for shared parental responsibility, which we always seem to focus on the material, so that one parent says that I don't even need any support, so I just want sole custody. And to me, we still don't end up with a whole child in terms of development. So let's put their interest above anything else, and let us try alternatives. Let the court, and I'm saying these are the risk of losing my job, if you don't bring cases here, then probably the Chief Justice might say that we don't need 6 magistrates, but I would rather, because I could now look for other alternatives and go to campus and teach. But for me, I think we would do well to just put the best interest of the children first and always have them in contemplation, whether we are thinking about divorce, whether we are thinking about separation, whether we are thinking about committing a crime in their presence or fighting in their presence. And thank you for the commitment of even following through the program until this is now 4:15. Thank you.
Thank you so much, Honorable Gitonga. We really appreciate you for taking time to just break down everything that a child goes through in court and the things you've experienced handling such cases. We, as LSK Nairobi, we really appreciate that you are a scholar in our webinar series. If you miss them, feel free to just hop into our YouTube channel. They'll be available there. And yes, as we continue, Mr. Ezekiel Kimani, kindly give us a parting shot.
This would be my parting shot. I have seen in most civil cases involving parties, the parties do not have any communication with each other. When especially when they get to court, the only communication they have between them is through their lawyers. What they need to do, because the relationship the two of them have is lifelong. As long as they are alive and as long as their children are alive, they must find a way of communicating. Because if they're in a position to communicate, then most of the problems that they take to court can actually be sorted out. The issue of telling the other party, no, talk to me through my lawyer, that is not a healthy thing to do. If the communication should be, if it must be limited, it should be limited only to the issues of children. But our communication is better, because even the children are affected when their parents who are not living together do not even talk to each other. Thank you.
So parents, that's a call to you to just be mindful of your children, be it that they're extremely young or below the age of 18. Just be mindful of what you do in front of your children. Let it not escalate to levels of violence or abuse, be it mental or emotional. Let's just be mindful of the children of this nation, because they are the future. And as you know, if we don't protect this young generation, then we are leaving the nation in hands of crooks, and we don't want that. So thank you so much to all panelists. We appreciate all the sentiments you've shared. As I mentioned before, there has already been development of change and discussions of change in the backgrounds just by having this webinar. So we hope that we can continue to have this discussion and maybe even offer trainings to civil servants and first-hand responders when it comes to children's cases, so that they may be able to handle such scenarios better. But we really appreciate you for your time. Thank you so much, the audience, for taking your time to listen throughout. You can reach us through our email, sknairobi@gmail.com. And for the recording of this video, it will be available on our YouTube channel as well as our Facebook. Thank you so much. We appreciate you. Have a lovely afternoon, evening actually, but thank you.
Thank you. Thank you. Thank you.